Hello, and welcome to Environmental Laws, Thompson Hine's Environmental Law Podcast. In each episode, you'll hear from subject matter specialist Thompson Hine and sometimes special guests on current events and hot-button issues in environmental law topics covering land, air, water, and safety laws. I'm Tanya Nesbitt, a partner in Thompson Hine's environmental and product liability practice groups, and I reside in our Atlanta office. I'm also a co-leader of the firm's greenwashing, defense, and litigation and extended producer responsibility teams. While I regularly handle all types of environmental law, I specialize in environmental litigation. In today's episode, we'll be discussing who pays for the package, EPR laws, and what every business needs to know. That recycling symbol on your packaging, it may mean less than you think and cost you more than you expect. A wave of state EPR laws is quietly reshaping who's responsible for plastics and paper packaging once it leaves the consumer's hands. Today, I'm joined by two experts from Geosyntec Consultants to break down what these laws actually require, where compliance gaps are hiding, and what businesses need to be doing right now. Let's meet our guest. Mark Heaney is a Senior Principal Regulatory Compliance and Global Product Stewardship Specialist based in New York and Washington, D.C., with more than 30 years of experience. As a leader of Geosyntec's Global Product Stewardship team, Mark focuses on product regulatory compliance and enforcement programs across a wide range of consumer and industrial products, pesticides, and chemicals. A key practice area for Mark is state-level product regulation and reporting, especially for packaging, extended producer responsibility, and emerging chemicals of concern. Our second guest, Erin LaCosta, is a project engineer in Geosyntec's New Jersey office. She first joined Geosyntec in 2016, then spent time in industry as a food process engineer before returning to Geosyntec. Since 2023, Erin has been building Geosyntec's extended producer responsibility support services, in addition to maintaining a practice in site remediation engineering. Welcome to the show, Mark and Erin. Let's begin, Mark, by learning a little bit about who and what Geosyntec does.
Sure. Thank you so much, Tanya. Erin and I are happy to be here. Appreciate the opportunity to collaborate with you and Thompson Hine today. Geosyntec is a global engineering and consulting firm with a large presence throughout the United States. Product stewardship is one of the core areas of practice that we have that's focused on supporting clients in bringing safe, effective, and compliant products to market and keeping them there. We have a strong focus on product chemistry, human health and ecological risk, and regulatory and supply chain compliance. Over the past several years, our expertise in, and quite frankly, clients' need for state-level extended producer responsibility program support, especially for packaging, has grown significantly and is, an area that Erin has been building a growing practice in.
Thanks, Mark. So just to set the table, I wanted to make our audience aware that extended producer responsibility does extend into plastics and paper packaging, textiles, batteries, tires, right? I think it's a growing area, certainly. But for today's discussion, when we talk about EPR, we're primarily going to be focusing on the laws that deal with paper packaging and food service ware, right? And we're going to look at recent state laws that are restructuring the state's recycling system by shifting essentially the financial responsibility for end-of-life management of those products to the producers. And the producers essentially are going to be the entities that are the brand owners, the manufacturers, the licensees, the importers and distributors. And so typically under state EPR laws, speaking generally, producers are required to register with the state, and they're required to report detailed information about the types and quantities of packaging materials they use and distribute in a particular state. And then they have to pay annual fees that reflect the environmental impacts of those materials. The states also impose fines for noncompliance and some hefty daily fines in some states. Or there could be product bans, right? there's a few states that say, if you're not registered with the stewardship organization, then you cannot sell products within the state. Of course, as expected, it has become, I think, a sore spot for industry, and there has been litigation. So we have litigation under Oregon's EPR law, as well as Colorado's EPR law for plastics and paper packaging. And in the Oregon litigation, we have a trade association there that has brought a number of about 5 constitutional challenges, both under the federal and the state constitution. That case there went to a hearing for a preliminary injunction that the court granted favorably there for the lead trade association. And it will eventually go to trial later this summer in July. And it seems as though many of the claims in the Oregon litigation sort of related to issues about transparency for fee setting and the methodology that was used to set fees. In the Colorado litigation, which is in state court, that more recent, but we see there that the challenges more so relate to the delegation of authority from the state to the PRO, Circular Action Alliance, to set up the stewardship organization. And there are also multiple constitutional claims in that litigation. And then also, I think there are some issues alleged about the setting of fees as well, and some of the reporting requirements. But the Colorado litigation, I think, was filed in March, so it's obviously trail the Oregon litigation. Generally speaking, I think an outcome in either of those cases will send shockwaves into the other states that have EPR laws, because the frameworks are very similar and the methodologies are very similar. And so a legal ruling in one state could potentially have consequences for the whole structure. We're continuing, obviously, to watch these legal challenges, and there may be others in other states. And so, Erin, I was just curious, from a consulting and compliance readiness perspective, what's your advice to a client, perhaps, who wants to use the uncertainty brought by the litigation as a reason to pause their EPR preparedness?
Yeah, thanks, Tanya. I definitely understand that initial reaction to consider taking a pause, but I think what's important to remember is that the plaintiffs for these lawsuits are trade associations, like you mentioned. So, for example, in Oregon, even though the judge has allowed that case to move forward and has paused enforcement, that enforcement pause does only apply to the members of that plaintiff trade association, the National Association of Wholesalers and Distributors. And then also that pause will only last until the case goes to trial in July. And so it's not a sure thing. We don't know how successful either case will be. And really, just in the meantime, you're losing valuable time to prepare your data and your reports and make strategic decisions about your packaging, which are all very time-consuming processes. And then, not to mention the product bans that you previously spoke about. So that is sort of looming in the distance and is a risk that you can't ignore.
Right, and I think that's correct. The injunctions are not statewide, and I know that there's been some activity, particularly in the Oregon case, where other trade associations are trying to intervene to enjoy the regulatory pause, but unclear sort of how that those decisions will eventually land by the court. And then, ultimately, this is not a compliance exercise that can be done overnight, right? You're going to lose valuable time in preparing your program. And ultimately, I think the policy of EPR is something that we're going to have to contend with in some form. I mean, I think the programs may look different and litigation may shape them to look differently. But I think the concern about the end life of plastics and packaging is something from a regulatory perspective that's not going to disappear. So, Mark, I'll turn to you. This obviously is a long process in terms of assessing packaging and determining your plastic components and looking at fee potential, right? And to potentially change packaging if you're in a state that requires that. Where do companies typically get this wrong or make missteps?
Sure. Thanks, Tanya. Erin and I I've been pondering this a bit for lessons learned for some of our clients and companies that are looking at this now. And there's kind of two levels where we've seen companies getting things wrong. I'll briefly discuss at the highest level. It's an applicability evaluation, and it's some of the basic assumptions that if a company doesn't make packaging, or if they're not located in a state that has an EPR program, then EPR for packaging doesn't apply to them. It's kind of a fairly basic level, but we've seen that multiple times, and that basic assumption can lead to real problems. I will state clearly, both of those assumptions are incorrect. It's based on where you sell products, not where you make them. So that is a core piece of applicability. And it's your product, the packaging, and connected to a product, both the packaging that holds the product and in many cases the packaging used in shipping. It's not about who made the packaging, it's about who owns the packaging around the product. But that's kind of at a very high level. I know I'm certain that Erin's probably got a few thoughts at a little more granular level on this if you want to chime in, Erin.
Sure. Yeah, I think you're totally right about all your points, Mark. And yeah, generally there's two important points to start with for EPR, and those are identifying the producer and then identifying covered material. And the key thing we'll always keep coming back to is to do this analysis on a state-by-state basis, because there are differences and nuances between all 7 that have EPR laws. But if we start with covered material, I think for the past 3 years, I've seen folks ask over and over again, does XYZ state have a business-to-business exemption? And I would say this question is not specific enough. So for Maine, their EPR law is focused on packaging used to get a product to the consumer of a product. So that can eliminate a lot of transport packaging, but at the end of the day, a consumer can still be a business. So it's not a pure business-to-business exemption. Similarly, in Colorado, the Producer Responsibility Organization, Circular Action Alliance, is currently focused on packaging managed in residential waste streams, but that's going to expand in the future. So again, it's critical to look at each state individually and always look back at the true definition of what a covered material is.
So speaking of states, so we have 7 that have enacted packaging EPR laws, and more are certainly coming. You know, you can see sort of the introduction of bills to create EPR programs in the future if you are monitoring sort of what is happening in various state legislatures. So how should a company approach building a compliance framework if you are selling nationally that doesn't require that you start over in every state each time a new state comes online?
That's a great question. Sorry, I'm jumping right in, Tanya. I think what we're finding is not only is it the addition of new states, but that all of the programs require annual reporting. So this is a program where it needs to become a programmatic, routine, and systematic compliance piece for businesses, where you're adding more complexity to it as more states come into things. And what we've looked at, and our clients who are a little further out ahead of this have worked on first identifying responsible entities for each state and understanding their packaging. And the primary piece comes to, across all of this, there are these common themes. You need to know your product and the packaging associated with it. Different states may have slightly different packaging categories and types, but in all instances, you need to know everything about the packaging, both the packaging holding the product and how things are shipped. With their shrink wrap around it, is there what's called dunnage involved in the shipping that can be reportable? And building that database across your entire product portfolio that is the core tool that businesses really need, irregardless of specific states. You have to know that packaging information, know your products. And I think that comes down to also knowing what's in your products to handle other state level regulation that's coming out. From there, you can build a regulatory database that shows the different states that are coming on board, what their requirements are, due dates, some of the applicability pieces. And then each year you're really taking your annual sales data, the packaging data, all of those items that you've built into this database, and filtering them through the requirements for each state. So you've got a centralized process for this instead of that piecemeal state by state. That also allows for greater control if you're ever audited, and for working at it from a compliance standpoint with legal counsel, having documented methodology for how you gather your data, how you make applicability decisions, the rationale behind it, and then how you report. So the concept is this needs to become routine and systematic environmental reporting, just like in standard facility management, things like wastewater, clean air, that have routine reporting requirements as well.
Yeah, very good suggestions, Mark, and also, filtering the information through the different state exemptions, right? It surprised you how often I speak to clients and they don't know what their tonnage is per state. And so, knowing those numbers ahead of time also, saves you money and time. So, Erin, turning to you, I know that California in particular has pretty stringent expectations related to the different plastic components of particular items, and the state has also set source reduction targets. Can you speak to what these requirements are and how they differ from other states that currently have EPR laws on paper and packaging?
Absolutely. Yeah, so for the non-California states, EPR it's for now mainly an exercise of reporting the weight of your packaging sold into the state and categorizing it appropriately. And then we'll talk later more about some of the incentives to make packaging changes and reduce weight and what have you. But California is its own entity, and what you need to know about this state is that baked into their statute, they have a requirement to reduce the net weight of plastic packaging and food serviceware and the net number of plastic components sold into the state, with the earliest reduction needing to happen by 2027. And this does not account for sales growth. They also have a requirement for all single-use packaging to be either compostable or recyclable by 2032. And so in order to accomplish these goals, as a producer, you're expected to not only report the weight of your packaging, but also the number of plastic packaging components sold into the state annually. Then on top of that, in order to meet the source reduction goals in the law, you are required to project out the different kinds of packaging changes you're planning to make and the expected impact of those changes. This is not a requirement in any other state, and it's called a individual source reduction plan. We're expecting that to be due sometime this summer. An additional requirement is that every year you will look back at the packaging changes that you've implemented and run that same analysis. How much, had I not made this packaging change, how much plastic would I have sold into the state? And so again, that's a requirement unique to California.
So we know that Oregon, Colorado, and California are already in active reporting phases. What are some early lessons from these programs that companies in states that haven't yet gone live should be sort of applying right now?
Yeah, I can take that question too. I think one of the biggest lessons we've learned is just how cross-functional of an exercise all of this is. So what you can start doing if you haven't already is just bringing the right groups from your company into this process. So of course you're going to need sales because you need to know what you've sold and where. Then you need packaging engineers and scientists who really have an understanding of what the packaging is made of and developing that database that Mark was talking about. IT resources are key because these can be this is a lot of data, especially if you have a lot of SKUs or if you have complicated packaging. And then, of course, legal counsel to help you navigate the applicability and some of the other items we've already been talking about. So get that group involved now, I would say is a really important lesson that we've learned.
So one thing we haven't talked about are the other emerging regimes that intersect with EPR. So we haven't talked about the number of PFAS restrictions, right, from reporting to outright bans of intentionally added PFAS in various states. There are recycled content mandates in various states. And then we have chasing arrow laws or laws that, particularly in California, that prohibit the use of chasing arrows unless the product can meet the recyclability threshold, and various other labeling laws. So, Mark, in building a fully compliant packaging program, how do all of these things intersect with EPR?
Tanya, you have hit on the item that, as they say, keeps me up at night, because as I mentioned earlier, it's really knowing your products and not, and packaging is a huge component now, but there is an emerging patchwork of state level product regulations addressing items like post-consumer recycled content, labeling laws, the chasing arrows laws, PFAS restrictions, PFAS reporting. I think we can all see microplastics coming down the line.
Absolutely.
There are just so many of these things rolling out that all point to know your product. And I think that's what the states are saying, big picture, especially where we don't see real federal leadership on these items. That's what's coming out. And EPR intersects because it's a bit at the front of the wave here, and it hammers knowing your supply chain, knowing your products, building the systems to be able to report. And then there are absolutely overlaps in knowing the regulations. You'd mentioned the Chasing Arrows law. The Chasing Arrows law out in California, I think it's State Bill 343, relies on definitions of recycling and recyclability that tie into State Bill 54, which is the California EPR law. So the two laws are actually they are linked together and depend on each other and kind of work as a system. So to make sure you're meeting the recyclability definition in SB 343, it's the same definition that they're using in SB 54. It relies on that. The Chasing Arrows law also includes PFAS content, something, I think it's 100 parts per million, if I recall. If it has more than 100 parts per million PFAS, the state said that is not considered recyclable. So PFAS content in packaging is tied to Chasing Arrows. So there's a lot of intermingling amongst these rules that EPR absolutely intersects with. But if you think of EPR as this is one of the leading waves for know your product and build these things in, it's continuing to build that content and the ability to filter, not just through EPR, but through these other product-specific regulations that are coming out.
I could add to just thinking about it, a positive spin, I guess I would say, is recycled content, for example. If you're meeting the requirements for some state-specific laws where they're only focused on recycled content, it's going to help you with EPR, right? Because there are incentives to increase recycled content in the EPR laws. So let's say you're already ahead of the game and complying with New Jersey's recycled content law. That's actually going to potentially help you with extended producer responsibility.
So Erin, you talked earlier just about the importance of sort of building a cross-functional team across an enterprise to get the data and information you need to achieve compliance in a more systematic, sort of routine way. While important, it sounds costly. And so can you talk a little bit more about some of the bigger cost drivers under EPR and how companies may be able to foresee them manage them and reduce them where appropriate?
Yeah, definitely. Yes, there's a major cost component to all of this. And I think at a high level, what we can say is, so the higher your packaging weight and the less recyclable your packaging, the higher your fees will be. And you can see this biggest signs that we have right now are the fees for Colorado and the fees for Oregon, which are publicly available. And what you can see is each state has an analysis of which category is recyclable in their area. The corresponding fee will be lower depending on whether or not they've got a check mark for recyclable or not recyclable. So that's going to be a major cost driver. On top of that, in California, there will be monetary incentives to comply and work towards those source reduction goals we were talking about. And then in California too, there will also be a plastic pollution mitigation fund, which is basically a fund that the state is raising money for. It's $500 million per year for, I believe, the next 10 years. And we don't know quite yet how they will distribute that amongst member producers, but just knowing that sheer number, I think, is helpful and a good bellwether to show just how much this is going to cost companies.
Thanks, Erin. I think that was pretty insightful and will give companies some perspective as to how to manage cost, particularly, as I mentioned earlier, more and more states are going to come online with these laws. And so it's something you have to plan for the future, at least for the time being, till we see the outcome of the litigation challenges. Mark, to close us out, in what ways can legal counsel and environmental consultants partner together to navigate EPR compliance? And not just EPR compliance. I mean, I think we talked about some of the other tie-ins with the chasing arrows and labeling and other state laws, but from a product sort of stewardship perspective, how can legal counsel and environmental consultants work and partner together to help companies meet their compliance requirements?
Sure. I think we've found over the last few years, the clients that have been most successful, there's a real partnership between legal counsel, both external and in-house, and the environmental consultants that they're working with. That partnership has provided the best results. A lot of the work involves privilege and needing to operate under privilege. You're gathering lots of data digging and understanding all of your products. And that when you're doing that deep a dive, it's always good to have that privilege and the legal counsel overseeing it. And this is a core compliance program, but it's also an emerging compliance area where people are still figuring things out. So having that constant presence of legal counsel really helps with risk management decisions and applicability decisions and documenting the methodologies and approaches up front that the consultant can work on. But you need to have that added insight from the legal team, particularly as you're building these practices. The other area where we've seen a real partnership is as the consultant is digging into data, working through the supply chains, contacting supply chain partners, we're finding there's a real need to, from the client end, potentially rework supply chain agreements. Supplier codes of conduct requiring compliance with state level regulations often exist, but do they include EPR? That needs the legal counsel involved. So there's some very specific areas that we've been finding where that partnership really works. And then the one last piece I'll put in, just to participate in EPR involves joining the producer responsibility organizations, which the consultant can help with, but it also involves executing producer participation agreements. And that's another area where it's critical to have legal counsel to understand what companies are signing on to in that relationship, especially when right now it's the same PRO for all 7 states.
Right. Well, Erin and Mark, this has been really enlightening. And Mark, to your point, I think states are still figuring this out, right? So this definitely is an emerging compliance area. It may shift a bit with the outcome of some of the litigation, but I do think the policy perspectives certainly are here to stay and will be enduring. And so generally speaking, the better that a enterprise knows its packaging and the recyclability of its packaging, it will be, I think, on better footing generally, and certainly the labeling and use of recyclable symbols is part of that. But I really appreciate you coming on today to share your expertise on this topic, and would love to have you back as this evolves. I'm sure we'll have lots to talk about.
Thank you so much, Tanya. We're happy to be here and really appreciate the partnership working with you.
Thanks so much, Tanya. This was a great conversation. Thank you for the invite.
Thanks, guys. Thank you for listening to Environmental Laws with Thompson Hine. I hope you found the information shared during today's program valuable. We welcome your questions about today's topic, as well as your suggestions for future programs. You can email me at tanya.nesbitt@thompsonhine.com. If you'd like to learn more about Thompson Hine's environmental group, please visit our website at thompsonhine.com. With over 400 lawyers and 11 offices, Thompson Hine is a full-service business law firm recognized for innovation and client service. Our Smart Path Plus approach provides clients with services that are predictable, efficient, and aligned with their short and long-term strategic goals. This podcast is for informational purposes only. It provides general information and not legal advice or opinions regarding specific facts. You may not edit, modify, or redistribute this podcast without permission.